Well, hello. Good afternoon if you're on the East Coast, and good morning if you're still way out west. My name is Aaron Lacey, and you are listening to ED's, or the U.S. Department of Education's, Increased Scrutiny of College Contracts with Online Program Managers. It's part of the higher education webinar series offered by the Higher Education Practice and Lobbying and Policy Practice here at Thompson Coburn LLP. While we're still waiting for folks to join, I'll go ahead and get through some housekeeping. First of all, if you have any questions during the webcast, you can always submit them through the Q&A widget that's at the bottom of your screen, and we'll try to answer these to the best of our ability. A copy of today's slide deck, by the way, is available in the resource widget, and we welcome you to download that. We're always thoughtful about trying to include live links for a lot of the resources that we reference in the slide deck, even when it's converted to PDF. So one of the advantages there is it sort of gives you easy access to a lot of that underlying resource material. You can find additional answers to some common technical issues that sometimes arise in the help widget at the bottom of your screen. With regard to continuing legal education, if you're an attorney type and one of the reasons you're tuning in is for CLE, this webinar is CLE accredited in California and Illinois for 1 hour of general CLE credit, and in Missouri for 1.2. The webinar is also CLE accredited in New York for 1 hour of experienced and transition credit. 1 hour of general CLE credit in Texas is pending. And keep in mind, we award CLE based on attendance for the entire 60 minutes, so please stay tuned in for the entire 60 minutes if you're looking for that CLE. Due to changes in jurisdictional requirements, you'll notice that we're no longer using automated pop-up attendance checks, which for a little while we were, but we are back to the secret words, which we had several years ago. So the CLE folks in the States keep changing up how they like it to be done. Today you'll see a couple of times secret words pop up. Please be watchful for that so you can select the secret word from the multiple choice list, and again, make sure to get your CLE credit. Finally, just a reminder, we do always have a post-webinar survey, and we are really grateful for the folks who can take time to fill that out. We do read them after every single webinar. You've heard me say it before, and I'll say it again. We try to make every webinar better than the one before, and the surveys really help us to do that. So please feel free. In case you don't know, Thompson Coburn is a law firm. So the folks you're going to hear from today are all lawyers. Our firm has offices all over the place, and the presenters today are sort of split between our St. Louis office and our Washington, D.C. office. We all are part of or participate in the firm's higher education practice, which is a group of attorneys at our firm who are dedicated either full-time or part-time to working with institutions of higher education or other participants sort of in the higher education space, like OPMs or servicers or in the old days guarantee agencies, et cetera. We have 3 presenters today. My name is Aaron Lacey. I'm the chair of our higher education practice and work in all different types of capacities and on all different types of issues for institutions of higher ed, but really focus a great deal on regulations and matters involving the U.S. Department of Education and federal financial aid. So these relationships between and among institutions and I'll say bundled service providers or OPMs are always of interest and something that we pay close attention to, as well as the incentive comp prohibition, which we're going to be talking about today. I am joined by 2 eminent attorneys and professionals. The first is my dear colleague and friend, Scott Goldschmidt, who was formerly Deputy General Counsel at Catholic University there in D.C. and has been now part of our practice for, I guess, 2 or 3 years, Scott, and does a lot of the same things I do and the rest of the practice does, but Scott has that unique perspective of having been in-house for many years, and so really appreciates what it's like to be sitting in the institutional chair negotiating various kinds of contracts and agreements, including those potentially with service providers. We're also joined, I'm grateful to say, by my another friend and colleague and the chair of our lobbying and policy practice, Chris Murray. Chris and I have practiced together for, I don't know, Chris, like 15 years. And Chris, as indicated, is a lobbyist and a policy advisor He heads up our entire lobbying and policy practice, but actually focuses on education and including higher education issues, and has done a great deal of thinking on OPM relationships and compensation, all those kinds of things. And he is our man inside the Beltway, so to speak. And I'm delighted he was able to join us, and you'll hear from him towards the end of the presentation, where he's going to look into his crystal ball a little bit for us. So here's the syllabus. And I wanted to emphasize, I mean, what really, we did a presentation last year on incentive compensation and did sort of a thorough review of it, and we've got a slide later that gives you a link to that presentation. You know, here we're focused more on the, not just incentive compensation, but the relationship between institutions and bundled service providers, and as a subset of bundled service providers, OPMs, and we'll talk about those terms in a few minutes. It is the recent GAO report that sort of got us thinking that it was time to do a presentation and to talk about what's going on. But I did want to emphasize, we're going to speak more broadly. Scott in particular later is going to really focus on the GAO report, but we wanted to start and talk a little more broadly just about, you know, what's going on with these relationships. How has the relationship between schools and OPMs evolved, particularly in the context sort of the incentive comp rule? And then we also wanted to look at some of the commentary out there and what's going on in the political space and the policy space. We wanted to talk about neg-reg a little bit and not exclusively the GAO report. So we're going to try to lay some foundation, go through a little bit of this history of incentive comp and OPMs. We want to talk about the rise of OPM, some of the warning shots we've seen in the last 2 or 3 years, and negotiated rulemaking. I'm going to try to get through all of that in about the first half. And then we're going to spend the second half with Scott really thinking about the GAO report and commenting on that, and then make sure we have time for Chris. The official CLE certified presentation is 60 minutes. But we have an additional 15 minutes after that on the platform where we're around for questions. So if you have questions and you want to ask them, just keep in mind we can go past the top of the next hour. Okay, so with that having been said, let's dive right in. A brief history of incentive comp and OPMs. It's always, as a regulatory guy, for me, it's so important to start sort of foundationally and understand what's going on here. So the incentive comp statute, I'm talking about the federal prohibition on providing incentive compensation payments to covered professionals, which would be recruiters or financial aid staff, based on their success in carrying out certain covered activities. It came up in 1992 was the first time it was created, and the statutory language hasn't changed. So that's something I want to kind of emphasize. I see at the top here it says 92 to 2021. I need to update that to 2022 because, to be clear, we still have the same statutory language that we've had from the get-go. It appears in the program participation agreement, both in terms of where it appears in statute. The statute says we're going to insert this concept in the program participation agreement, which is the agreement between the U.S. Department of Ed and the school. And it essentially says if schools want to participate in Title IV, they have to sign this agreement and agree that they will do all of these things. And one of the things they have to agree to do, as you can see with the statutory language, is to not provide any commission, bonus, or other incentive payment based directly or indirectly on success in securing enrollments or financial aid to any persons or entities engaged in any student recruiting or admission activities or in making decisions regarding the award of student financial assistance, okay, except, and there's a carve-out, for recruiting of foreign students that are overseas. So essentially, if you're in the higher education business, you are prohibited from treating recruiters like sales staff would be treated at many industries in the United States, where they can simply be paid based on their success in recruiting. Again, it is true that this extends to financial aid staff. I will tell you, in my career, I have never had a meaningful conversation with an institution or any other player about the application of the incentive compensation prohibition to financial aid. It is almost always comes up in the context of recruiting or recruiting type activity. So the Department of Education, after this statutory language was first introduced in '94, introduced its first regulation, which it was directed to do to sort of carry out this provision, and it modified a little bit. In the preamble to the proposed rule, the department indicated its intention, quote, to extend this provision to require that institutions also may not contract with entities that improperly provide any commission, bonus, or other incentive payment. And this is a logical extension of the rule, right? It wouldn't be much of a rule if an institution could just contract with a third party, and then that third party could then carry out all the covered recruiting activities and pay its recruiters based on their success, right? So it seems a pretty clear next step for the department to clarify that, you can't do it in-house with your own recruiting staff if you're an institution, nor can you simply outsource the recruiting function so that the outsourced entity could then pay its recruiting staff based on incentive comp. So it's not just your own recruiters, it's anyone you contract with to carry out recruiting activities. And this is going to come up and be important in our discussion around why this rule touches on the OPM relationship, right? So in the 1994 final regulation, that was the preamble. I just want to highlight when you actually got the regulatory version of the incentive comp prohibition back in 94, they were very clear to start out and say it will not provide nor contract with any entity that provides any commission, bonus, or other incentive payment. From 94 to 2002, I won't read this whole quote, but it's a great quote from one of our old colleagues and mentors, Blaine Butner, who was at the Dowlonas and then Cooley Law Firm for many years, and an expert in this area. He pretty much highlighted and said it succinctly here that from 94 to 2002, the department started issuing a lot of guidance in private letters, and sometimes that guidance was consistent and sometimes it wasn't consistent, and it created a bit of a quagmire for institutions that were trying to figure out just how or sort of where the limits of the incentive comp prohibition lied. Because there were a lot of, when you read the rule or the prohibition, I think conceptually you read it and you think, oh, it's not really that complicated, but then you start to sort of contemplate its application to all different kinds of activities. What about recruiting for non-Title IV programs? What about the application to agreements like with bundled services providers? What if you've got an employee that is going out and negotiating contracts for training with other institutions, so sort of a business-to-business type function? Could you pay them based on the success of how many contracts they put in place? What if you want to promote employees during the year and they're getting a salary increase based on those promotions? Is there danger that that might violate the prohibition? So as is always the case, the devil's in the details, and as schools started to try to comply with incentive comp and this prohibition, which, by the way, applies to all institutions of higher education, just to make very clear, this is not a sector-specific rule. Everybody's covered by this. As schools tried to start to comply with it, they started to realize that figuring out how and to what extent it applied to all these different scenarios was complicated. They reached out to the department for guidance, and then we started to get this sort of web of difficult to decipher informal guidance back from the feds. With the result, for this and other reasons, in 2002, under the Bush administration, the department decided to expand in the regulation, and they introduced this idea of 12 safe harbors. So they said, we've got 12 types of activities, payment arrangements, based on all these conversations we've had over the last 9 years, that we now want to say, if you're doing these things in this way, it's okay, and it's not violating an incentive comp. So the notion here was to try to give institutions some sort of buckets of safety or safe harbors, and they knew if they were engaging in particular activities, they didn't have to worry that they were violating the rule. One of those safe harbors, it was actually number 12, I'm going to read it to you, it's the second bullet on the screen here, was payments to third parties, including tuition sharing arrangements, that deliver various services to the institution, even if one of the services involves recruiting or admission activities or the awarding of Title IV HEA program funds, provided that the individuals performing recruitment or admissions activities or the awarding of Title IV by that entity, right, the third party, are not compensated in a manner that would otherwise be impermissible. So what's interesting is way back in 2002, the department actually created a safe harbor. So this was something, these relationships with service providers, where the service provider was doing recruiting, potentially covered recruiting activities, marketing, but also other things. The department expressly contemplated this idea, and back in 2002 said, you know what, it's okay as long as the folks who are carrying out those recruiting functions aren't themselves being paid, right, on the basis of their success recruiting. But otherwise, you could work out a revenue share type arrangement with that service provider. And what we're going to see later is these types of service providers became known as bundled service providers. So the notion was you had some third-party entity that was providing the institution with a bona fide bundle of services that included, among other things, recruiting or admissions activities, and they were being paid a share of revenue for carrying out those activities. All right, so 8 years goes by, and the Obama administration says, we don't like the safe harbors. right? They say, we've looked back since the safe harbors were put in place in '02, and the department's experience demonstrates to us that unscrupulous actors routinely rely upon these safe harbors to circumvent the intent of the incentive comp prohibition, right? So in the commentary to the proposed rule, the department detailed each, and this is back in 2010, the department went through in that commentary and detailed each one of the 12 safe harbors, including the one we just looked at that provided sort of a safe harbor for bundled services arrangements that were based on a rev share. And the department detailed all 12 and said why they viewed them all as, quote, inappropriate or unnecessary. And then they took them all out, okay? So from 94 to '02, it was the wild, wild west. And then from '02 to 2010, you had this specific safe harbor in the law. It was number 12 of the old 12 that got at bundled service provider relationships. And then in 2010, the Obama administration says, we think that all 12 of these have problems, and so we're taking them all off the books. All right. But, and this is where it gets really interesting, but the department, subsequent to issuing the new regulation that had stripped out all 12 of the all 12 of the safe harbors, the department issued guidance in 2011 that got into a lot more detail around incentive comp and certain questions that have been asked around the incentive comp rule. By the way, this is still, for my money, the seminal guidance around incentive comp. I mean, you've got the 2010 rule, which is still in place, by the way, has not changed. So that rule that stripped out the 12 safe harbors, that is still the rule that's on the books. Statute hasn't changed since '94. And this guidance that was released in 2011 is still the critical guidance. So what's interesting is, apart from reviewing, sort of case law or administrative law judge decisions out of the department, for the most part, if you really want to wrap your brain around the universe of incentive comp law and guidance, that's what you got to look at. There's not a whole lot more to it, right? It's the current statute, the current rule, and this guidance from 2011. And we've got a link here for you to the Dear Colleague letter. By the way, it's a little confusing. So the department issued, a fixed format Dear Colleague letter, meaning that this letter itself has not changed, back in 2011. And then shortly after that, they essentially took the entire Dear Colleague letter and put it on their website. And if you look, you can see a picture here to the right. This is a screenshot. The website is not called, well, it does say incentive comp, but it says Program Integrity Questions and Answers, Incentive Compensation. And it's basically the Dear Colleague reprinted, except that when you scroll all the way down to the bottom of the website, there are a couple of additional Q&A questions that the department added later in 2014 and 2015. So just keep in mind, if you're looking at the Dear Colleague letter that was actually printed in 2011, you don't get that little bit of extra mustard that's at the very bottom of this website. So what you really want to do is you want to look at both, and you want to make sure to scroll all the way down to the website to get the little bit of extra. And that's particularly important because the two questions that were added, in addition to what's in the Dear Colleague letter, both get at bundled service provider relationships and revenue share relationships. So you want to make sure to read all of that. So in that 2011 guidance, they covered a lot of important things that weren't clear. Remember, they stripped out the 12 safe harbors, but then they in the guidance revisited some of these concepts and talked about them. So, and they offered this table of covered and exempt activities, which is helpful, and a table of permissible and prohibited payment types. But then, and I've got it right here in red, they talk about the discussion of revenue share, or there's a discussion of revenue sharing arrangements and of this concept of bundled service providers. And here's what they had to say. And keep in mind, the department had a safe harbor for bundled service providers in place. It was number 12 from '02. And in the preamble, they said, we took all of these out because they were all inappropriate or unnecessary. So they've effectively taken the position in the preamble to the regulation, which is then subsequently evidenced by their stripping out of all 12 safe harbors, that those 12 safe harbors were not okay, that there was a problem with them. So what's really fascinating is then they turn around in this guidance that they put out in March of 2011, and they essentially allow for these bundled services agreements provided certain conditions are met. So in the 2011 DCL, and remember, this guidance still stands, the department emphasized its general position that any payment based on the amount of tuition generated is an indirect payment of compensation based on success in recruitment and is therefore prohibited. So I want to emphasize this. Even in the 2011 guidance, the department's starting point, their baseline is you can't do rev share arrangements. Any payment, right, any payment based on the amount of tuition generated is an indirect payment of compensation based on success in recruitment. So they sort of set the floor and say, well, we, consistent with, our preamble to the new regs and our act to strip out the 12 safe harbors, our starting point here is that as a general matter, if you're even under contract, if you're paying someone to carry out recruiting services and you're giving them a share of revenue generated off their recruiting efforts, that would not be permissible under incentive comp. But then there's the big however. However, the department then goes on to recognize sort of a new safe harbor. Keep in mind, it's no longer in the regulation, so it's not in the law, it's just in sub-guidance, a new safe harbor for unaffiliated bundled service providers, observing that, quote, the department does not consider payment based on the amount of tuition generated by an institution to violate the incentive comp ban if that payment compensates an unaffiliated third party that provides a set of services that may include recruitment services. So one thing to note here, by the way, is that a bundled service provider relationship does not have to include covered recruiting services. And we know from our work with institutions and some bundled service providers that there are many out there, or at least some, for whom recruiting is not part of the package of bundled service. And if that's the case, then you really don't have an incentive comp question, right? In other words, if your contract with your BSP, if the BSP isn't carrying out any covered activities that would be subject to the incentive comp prohibition, meaning recruiting activities or financial aid, then there's no application of incentive comp, and this whole rev share question goes away. So where the rubber hits the road is when you have an agreement with a bundled services provider that includes some type of covered activity. So they're carrying out a covered activity on your behalf, right? But what the department is saying here is if it's structured the right way, despite the fact that we just eliminated that safe harbor, and despite the fact that in the preamble we just said we thought that safe harbor was potentially inappropriate, we're going to allow it. Now, the department doesn't give a specific list, but if you look at the guidance in 2011, their discussion, and then they have some examples that they give. If you go through that, you can pull out from those examples and discussion what essentially are the criterion for a BSP arrangement, bundled services provider arrangement, to take advantage of this safe harbor that's in the guidance, right? So they basically say it would be permissible if the service provider is independent from the institution receiving the services, both as a corporate matter and as a decision maker. The service providers can't be affiliated with any other institution that provides educational services, which has been a great frustration, by the way, to some of the institutions out there who feel like they have the ability to create potentially a subsidiary or division that could be a bundled services provider to other schools, right? But if they do that and they want to engage in recruiting services, they can't take advantage of this safe harbor because that sub or affiliate would be related to an institution that provides educational services. Not the one that's receiving the services, but just an institution, which is one reason you haven't seen some, I would suggest, very large and capable institutions moving themselves into a role of being a bundled services provider, right? The service provider has to offer a genuine bundle of services. Okay, so it really does need to be what I call a bona fide bundle of services, not just recruitment with a little extra. The tuition share has to be based or is based on tuition generated as a result of all the services, right? The service provider does not make incentive payments to its own employees. So remember, even when you satisfy all these conditions, that BSP can't turn around and provide incentive compensation to its own employees who are carrying out the covered functions. And then the institution does not make separate payments for the student recruitment services, right? So you can't have sort of one contract that covers everything but recruiting and another contract or payment mechanism that just covers the recruiting. So this core guidance right here, this is what this market of bundled services providers and OPMs has been relying on. Insofar as their contracts include recruiting services and they're using a tuition revenue share, a revenue share model for purposes of the compensation since 2011. By the way, I'll take a a deep breath here just to clarify. So a bundled services provider is the biggest bucket. That would be any third party with which you as an institution might contract to provide a bundle of services. That does not have to be online platform management, right? I mean, you could have a contract with a bundled services providers that does outcomes assistance or career services or employment placement or something that may not have anything to do with the online offering of programs, right? OPMs, as you know, online platform managers are sort of specifically this bucket of BSPs. So they're the sort of smaller group that, or conceptually speaking, that does a very specific kind of, offers a sort of a more specific set of services, right? Now they are very large, and I don't know about revenue, probably dominate bundled services providers arrangements. But I just want to be clear, when the department doesn't use the term OPM in its law and guidance. It uses the term bundled services provider, which is sort of, again, conceptually broader. And OPMs are, categorically speaking, a subset of bundled services providers. Okay, so let's talk about the rise of OPMs, because the fact is, when this guidance came out in 2011, the OPMs weren't the thing that they are today, anywhere close. In some 2017 research by EduVentures, some of this, by the way, is discussed in the GAO report that Scott's going to cover in a few minutes, and some of it is discussed elsewhere. But in the 2017 research by EduVentures, they found that the number of institutions that had contracted with OPMs had grown more than 130% between 2011, when that guidance came out, and 2015, with more than 300 schools using OPMs. Now, some of this may have to do with the guidance, but to be fair, I'm sure some of it also just has to do with the fact that over time, OPMs have gotten better at what they do, and online education has been more widely accepted, and, you know, wireless access and smartphones, all those things have improved. So, you know, I'm sure there are reasons beyond just the guidance, but it is noteworthy that this OPM growth really began and took off after 2011, when there was now some security for the market that they would be able to use a revenue share arrangement and engage in recruiting services. Because until that March 2011 guidance came out, there was at least a period after the department got rid of the safe harbor that had been put in place in 2002. You know, there was a period where there's a big question mark. If the department didn't come out and say in some way or another these arrangements would still be okay, you probably would have seen OPM growth look a little bit different, although my expectation is they probably would have figured out an alternative comp model. But certainly the sanctioning by the guidance of the rev share model was helpful, right? In the recent GAO report, which is more, you know, just last month, the agency concluded that at least 550 colleges worked with an online program manager to support at least 2,900 education programs as of July 2021, and that about 90% of the colleges with OPM arrangements are public or nonprofit colleges, which also is worth highlighting. Business Wire observed that the market was at about $3.9 billion in 2019 and expected it to reach $11.9 by 2027. And keep in mind that in 2019 we were pre-pandemic. So that projection of $11.9 billion was not based on a world where, you know, in 2020, 75% of students went online, which, as many of you will expect, significantly augmented the growth of OPMs and their trajectory, even beyond what was already sort of impressive growth. Speaking of growth, the GAO report uses data from ListEdTech, which is a education data analytics firm. They actually used ListEdTech's own data for the purposes of the GAO report, and ListEdTech has really great OPM information apart from the GAO report, just available online on their website. So giving them credit, both of these charts come from their website. So the first one you're seeing on your screen now is new programs offered with OPMs from 2003 to 2021. Boy, a picture's worth 1,000 words, right? So you see from 2003 to 2011, I mean, there's this very modest growth. Very modest growth, right? And then in 2011, again, I don't want to say it's all due to the guidance, but that's a pretty sharp curve, right? From 11 to 13 and then just really taking off from 13 to 2021. I'll also suggest that maybe some of this has been driven by the struggles and contraction we've seen in higher ed. You know, you've got a lot of smaller institutions, some geographically isolated private liberal arts institutions in particular, that have been struggling to figure out their direction and to find an economic model that might work for them on a go-forward basis. A lot of research out there around these ideas. Chronicle Inside Higher Ed, others have a lot of great content. And we've seen many of our clients that might fit that profile look to OPM relationships potentially as a way to reinvent who they are and who their students are, and to potentially expand enrollments, et cetera. So I think, you've got the March 11 guidance that confirms for the industry that there is still a way to create relationships with schools that can utilize recruiting services and a rev share arrangement, but stay clear of incentive comp. So with that sanctioning, then you've got schools looking for solutions, right, for enrollment decline, et cetera, and that really fueled, among many other things, I'm sure, this growth. Another great slide from List EdTech that you can find on their website. So here you see what's interesting is this gives a slightly different perspective. This is new agreements with OPMs from 02 to 2021. And you see that you don't have that same sort of sense of things really taking off after 2011, right? I mean, you look like you've got under 50 new agreements in 2011, a few more actually in 2010, and then 12 and 13 you see some real modest growth. But then in 14 you jump, it looks like over 50%, right? I mean, you're heading up towards 100, 14 and 15, and then for the first time in 2016 you get up over 100, and we see new agreements over 100 every year since then. And of course, the big jump is in 2020 when the pandemic hits, right? So you already have this growth occurring in the marketplace, and suddenly all these institutions need to find some way, in many cases, to educate their existing student body online. And of course, at the same time, by the way, you've got the department and accreditors and other regulators giving some additional flexibility to these institutions to go into the online space. Okay, here's our first secret word, by the way. So you'll see there are 3 choices on the screen. I have been instructed by my handlers and managers to give you a solid 30 seconds to take a good look at that. So this is I like this. This seems a very refined set of choices. I'm sort of imagining some sort of afternoon break to take advantage of these kinds of things. Hopefully you've got something near you to help get you through the afternoon and a session on OPMs and contracts. Okay, so hopefully you've had a chance to see your second word. I promised my colleagues I would get done here, so I'm going to pick up the pace to make sure we get where we need to be, and you have lots of time to hear from Scott and Chris. But what I wanted to highlight here is that after all this occurred, there were folks who were even part of the administration and who signed off on, the perpetuation of the bundled services provider concept in the guidance, who later began to regret it, particularly as the OPM market took off. And they sort of viewed this, I think they viewed these relationships in some cases as not being healthy for higher education. Interestingly, Bob Shireman, who was part of the Obama administration and one of the folks in the room when this occurred, in 2019 wrote an op-ed that was featured Inside Higher Ed. And his feeling was, and he just acknowledged in the article, that the exception really isn't working. As many colleges pay a share of every tuition to online program management companies, it would seem to present a pretty clear violation of the ban that Congress enacted and which remains supposedly the law of the land. Okay? So his position is not that, and this is an important concept, his position is not that the BSP exception should be rescinded because something has changed, because, the industry's grown too much, or the relationships aren't working out, or private third parties are having too much influence on program platforms and content decisions. What he really leads with in his op-ed is it should be rescinded because the BSP exception's always been inconsistent with the law. Right? And this goes back to 2010 when they stripped out the safe harbor. And they even said, remember, that all of these safe harbors are inappropriate or unnecessary. Right? So they sort of took this position as illegal. Even in the 2011 guidance, they started out with this notion that, look, if you're paying even a third party in this way, it's not consistent with the prohibition on incentive comp. So it begs the question, why did the administration back in 2011 include the BSP exception? And Shireman answers this question directly in the op-ed. He says, lobbyists using the names of trusted and politically powerful universities certainly made a difference. Beyond that, policymakers, including myself, wanted to view the companies as white hat warriors helping to build nonprofit and public alternatives to predatory for-profit online colleges. I don't think it's reading between the lines here. I think, and to me, and I was talking with Chris and Scott about this yesterday, it's just fascinating that Shireman, who was in the room and part of the group that created this guidance, essentially is conceding that the department was willing to issue that guidance knowing it was inconsistent with the law and believing it was inconsistent with the law, as evidenced from the preamble to the 2010 rule, in order to appease lobbyists and to advance a separate agenda. In this case, sort of the crackdown on for-profit institutions. So it's really fascinating to me that this is just a black and white right there in the op-ed. But, times have changed, and it evidences, and this is an important point, it evidences the extent to which Bob Shireman and others really view these relationships as problematic, right? The fact that they would be willing in writing to essentially say, we did something we should not have done for reasons probably that weren't appropriate if you're conceding that it's illegal, right? And that if you're conceding your view that these arrangements are prohibited under the law, then there's probably not a good justification then for issuing guidance that says they're okay. And that's his current position, and it's important to note, folks listening, that it's the current position of some of the folks inside the department right now and others who are thinking a lot about this. He basically said, and this is another quote, with the apparent continued federal endorsement of their modus operandi, the OPM industry took off. All was not well. The idea that OPMs would bring cost reductions to education consumers was not materializing. Several exposés exposed downsides in terms of cost, the hazard of incentivizing predatory recruiting, OPMs that take large shares of tuition. These monster contracts are a far cry from the small online extension programs BISC, which was the entity he cites in his op-ed as having been influential back in the day, described when the company defended the bundling loophole. If you don't like something, right, in policy circles, if you don't like it, you call it a loophole. The bundling loophole to me a decade ago. All right, so he says corrective action is indeed needed. And he says, what do I think policymakers should do? Institutions should be required to disclose the companies running their programs. The department could decide to rescind or revise the guidance, or, and he seems to be suggesting maybe that someone think about this, the question of the validity of the guidance could come before a judge. So in other words, somebody could sue or bring this to court to try to see if you could get a court to say the guidance is inconsistent with the statute and with the regulation. So there are clearly opponents out there. And by the way, to be clear, there are those who feel very strongly, not just OPMs in schools, but others who feel strongly that and disagree with Bob Shireman's views, right? I mean, and in fact, following his op-ed, there were additional commentators that argued both for and against OPMs, and there was some pretty interesting conversation that occurred in 2019 and in 2020 and 2021. Just a couple of examples here. Eric Gilbert had an article that was more in line with Shireman's views. He's a professor down at the University of Arkansas. And then Kelly Otter had both of these articles, by the way, I think were in the Chronicle, had sort of a counterpoint, online program managers are not the enemy. By the way, my apologies to Kelly. We have misspelled her name here. It is Kelly, and we will get that fixed in the slides and in the presentation that are posted afterwards. So my apologies to Kelly. But so there's been a lot of back and forth, right, over the value of these relationships. And keep in mind, some of it is more broadly about the value of the relationship. Some of it is more specifically about revenue sharing and incentive comp, right, and whether the relationships, if structured a certain way, violate that particular law. Then beginning in 2020, a group of senators, as some of you are likely aware, began an inquiry into the nature and breadth of OPM arrangements, and they started sending data request letters to some of the biggest OPM providers. And we've got links to these articles. We've got links to the letters from the senators if you'd like to take a look at those. Now, all of this has sort of created momentum and what we're seeing is the department starting to take action. And while hopefully you're aware of the GAO report, which Scott's going to get into in a minute, the first thing I wanted to highlight for you, which some of our clients were not aware of, is that the department's first effort to really dig into OPMs and these relationships actually has not come through incentive comp, but from a different direction around tax status and arose in the context of the recent negotiated rulemaking that occurred earlier this year. So as you may know, the department is engaged in a broad and sweeping revision of regulations that oversee institutions of higher education. There are two major negotiated rulemakings that were held, one last fall, one this spring, covering 17 separate issue areas, many of them significant and complex. They're all on this slide. If you're not aware of this and you are tasked with being aware of these kinds of things at your institution, please plug in, because you're going to start seeing proposed rules coming out of the department, and it's really important that institutions are paying attention and commenting if they have concerns, or if you support what the department's doing. There are things you think they're doing that really should be in the law. You should also write comments and be supportive, right? One of the things the department considered this spring as part of the institutional programmatic eligibility rulemaking was the change of ownership and control processes. And those tend to be very technical. For obvious reasons, not a lot of schools are going to be plugged that in because the vast majority of schools are not going through a change of ownership or control. But what was interesting was, as part of that issue paper that was dealing with ownership and changes in control, the department introduced a new definition of nonprofit institution. And there are a couple of things that are really important that I want to highlight for you here. The first, which the department punted on when asked specifically during NEGREG, but that I want to get at is this definition of nonprofit institution, I believe, and I think we will see guidance on this topic, is intended to apply, and let me be very clear, to both private nonprofit institutions and public institutions, right? And we saw this because in the third round, when the department put out its final version of this definition, it changed this opening you see here. And by the way, what you're seeing here, to be clear, the department during NEGREG will actually put out proposed language. They're saying, you know, this is what we want to change in the current law. So this was the last version of the department's draft language. Now, it's not a proposed reg yet. We'll see that when the notice of proposed rulemaking comes out. This is just sort of what the department said, hey, we think this is something you ought to look at. So if you look at 1I, it says, for a domestic institution, so this is the definition of nonprofit. For a domestic institution, no part of the net earnings of the institution can benefit any private entity or natural person. And for a private nonprofit institution, the institution, and it says, has to comply with A, B, and C here. But what that tells you is that the general definition of nonprofit in this lead-in is almost certainly intended to apply to all nonprofit institutions, public and private alike, because they're drawing a distinction between sort of the general definition and A, B, and C, which are only intended to apply to private nonprofit institutions. So for starters, I believe what you're going to see on the next slide is intended to apply both to public and private nonprofit institutions. And that makes sense because if these guys at the department are trying to get at OPM relationships, it would not be helpful to them to exclude public institutions, which make a decent chunk of those out there that have OPM relationships. Okay, so this is the language I really want you to see, and it's B that we're really focused on. So they said, remember in that prior slide, it said a nonprofit institution, right? You can't, let me just go back, right? It says a nonprofit institution, you can't have any part of the net earnings of the institution that benefit any private entity or natural person. Sort of consistent with the standard that you have to meet for the IRS, right? What the department is saying here is, when the department makes a determination regarding net earnings, the secretary considers the entirety of the relationship between the institution, the entities in its ownership structure, and other parties. By way of example, a nonprofit institution is generally not an institution that, and look at B, either directly or through an entity in its ownership chain, enters into or maintains a revenue sharing agreement with any party, including related to or unrelated parties, former owner, etc., unless the institution demonstrates that payments under the revenue sharing agreement are reasonable based on the market price for such services or materials, including demonstrating a reasonable relationship to the cost of the services or materials provided. What does this mean? Okay, so what this means is in the future, and you might say, by the way, well, how can the Department of Education say we don't qualify as a nonprofit when the IRS can? Keep in mind, they can't, right? Meaning they can't make let me rephrase that. They can't decide for the IRS. So the IRS makes its own determination. But what the department can do is they can say, for purposes of our regulations, we get to decide who we treat as a nonprofit. And what they are saying here is, if you have a revenue sharing based arrangement, and I want to point out here that there's nothing in here about incentive compensation or covered recruiting activities or anything. It just says if you have any agreement that is a revenue sharing agreement with any third party, right? Bundled service provider, it doesn't matter. that you have to demonstrate that the payments under that revenue sharing agreement are reasonable based on market price for such services or materials. So this is not about incentive comp. This is about the department saying, if you want to be categorized and treated as a nonprofit, then you may have to demonstrate to us that that revenue share that you're paying to whoever that third party may be, I mean, it could be your bookstore, it could be your career services, it could be anybody out there. If you've got a revenue share arrangement, you're going to have to demonstrate potentially that there's a market-based, rationale for the percentage that's being paid, right? And if you don't, what's the upshot? Theoretically, the department's saying they wouldn't treat you as a nonprofit. So this is crazy. But what the department is really suggesting here, and I'm just going to pick a name out of a hat, right? But I'm from Louisiana, so I'm just going to pick on LSU. So they're saying if LSU has a revenue sharing arrangement, flagship state university, and they can't satisfy this standard, theoretically the department might decide to treat them as a proprietary institution. I think that's a pretty big ask, but that's what this regulation suggests. And my suggestion to you is that if you have OPM relationships or bundled services provider relationships, you need to keep a lookout for this proposed language when it shows up from the department. It's going to be hotly contested. The trade associations in D.C. are paying attention. Others are paying attention. But it did kind of sneak in a place where I'm not sure everybody was really plugged in. Rulemaking next steps, just so you know, there was no consensus on this issue paper or around this definition. The department next will have to issue a proposed rule, right? And then you'll have an opportunity as a school or an OPM or any other member of the public to comment on that proposed rule, and then they will issue a final rule. So be on the lookout for the proposed rule that gets at these change in ownership concepts, and in particular for this proposed definition around nonprofit, because the implications are very significant. Finally, if you want to follow NEGREG more closely, you can go to this webpage. All the stuff, all their drafts and their proposals, everything is right here on this page. All right, Scott. Boy, I delivered it a little late, but I'm sending it over to you for the GAO report, my friend.
No problem. Thanks, Aaron. So good. So as Aaron said, I'm going to hopefully walk through the GAO report in the next few slides. So for those of you that may not be aware, GAO is the Government Accountability Office. It's an independent, nonpartisan agency of the legislative branch that advises Congress. The GAO can prepare a report at the request of any member of Congress on congressional committee on topics of public interest. A few years ago, several Democratic members of Congress requested this report on OPMs, and that's what we have here. So on May 5th, 2022, the report was finally delivered. It examines the Department of Education's oversight of OPM arrangements and specifically their compliance with the prohibition on incentive compensation, as Aaron detailed in great detail previously. As you know, this is a relatively narrow scope for this report. May be surprising to many members of the education community. It does not address all aspects of the relationship between OPMs and institutions, but really just focuses on ED's role in ensuring institutional compliance with the federal ban on incentive compensation. It's also a fairly neutral report. GAO didn't report any violations of federal laws or really call out any kind of big blockbuster issues. It was really just a detailing of the relationships and ED's oversight of this important issue. So what does the report do? I said it's not that broad. It really echoes a lot of Bob Shireman's concerns. First, that the arrangements between institutions of higher education and OPMs are dramatically increasing. A lot of the slides and data that Aaron went through are included in the report in detail. And it also addresses concerns that arrangements often include recruiting services that are subject to the ban of incentive compensation. The report asserts that while ED is responsible for enforcing this ban, it's just not obtaining the information it needs to detect violations during its regular compliance office and program reviews, and as we'll talk about, provides recommendations for how that can occur. Notably, and we really want to call out this piece of the report, it affirms that the incentive compensation prohibition extends to OPM relationships that strictly involve non-Title IV programs. In particular, this is paraphrasing the quote, but the ban does not rely on federal student eligibility of individual education programs, and explains that payments can violate the incentive compensation ban even if those payments are strictly related to student recruiting for programs that are not eligible for federal student aid, short-term programs. So why is this important? Why are we calling this out? Well, it's really the first time in our experience that we've seen this information that the incentive compensation prohibition applies to non-Title IV programs is so clearly stated in writing by the federal government. Remember, Aaron went through the 12 safe harbors during his presentation. He focused on the one related to bundled services agreement, but the second of these safe harbors dealt with this very issue, that there was a safe harbor that recruitment into programs that are not eligible for FSA program funds are kind of treated as a safe harbor, and this, along with the other 11, was explicitly stripped out. The department saying that institutions use this safe harbor to steer students away from Title IV HEA programs and manipulate the system. But kind of based on stripping that out, it left a question about whether this has been permitted, whether this would be permitted. And in our experience, a lot of colleges and universities are still under the assumption, or there's still a question about whether non-Title IV programs are covered. This suggests otherwise, and we just wanted to highlight that it's particularly worth your consideration.
And Scott,
so the GAO report.
I just wanted to highlight too, tying it back to the OPM point. It also means if you've got an OPM contract or a bundled services contract, and that provider is only offering non-Title IV programming or services. So let's say you got an OPM relationship with a provider that does boot camps, right, that are not short-term, not Title IV. The implication of the position here that the GAO then goes on to sort of connect the dots is they're saying it doesn't matter if your OPM relationship is with a provider that's strictly non-Title IV. It's an institution-level commitment. So it's not just Scott's right. I mean, it's the first time we've seen it like this in writing, but it also has real implications here because it suggests that even where you have OPM relationships, where your provider is you know, the content of the programs they're licensing to you, et cetera, are strictly non-Title IV, the GAO is asserting that you still have to comply with the incentive comp prohibition. Sorry, Scott.
Yeah. No, not at all. That's a great point, Aaron. And a little later, we'll talk about how GAO defines OPMs, and that leads right into that. But first, let's talk briefly about the two recommendations. So out of this report that we waited years for, the GAO issued two recommendations. First, they recommended that enhanced instructions for auditors be provided. So the secretary should provide instructions for auditors for the compliance supplement, so auditors can better identify and assess potential violations of incentive comp. And as you notice at the end of that first box there, that first recommendation, GAO specifically references the 2011 Dear Colleague letter, what Aaron talked about as the kind of the seminal guidance here. So that's officially kind of incorporated into GAO's recommendation. And the second recommendation here is to provide more scrutiny during audits and program reviews for colleges. So again, the secretary should provide additional instructions to colleges and institutions regarding information they must provide. And that includes identifying OPM contracts and things like that. So one instruction kind of for auditors, one instruction for colleges, but something, both of them, that institutions will certainly be asked about, and to start considering how you might respond to these instructions when they are given. Ed provided a response in the GAO report and concurred with both recommendations. In response to the first, Ed agreed to propose revisions to the compliance supplement to provide relevant guidance with incentive comp. In response to the second recommendation, Ed agreed to reinforce that the ban on incentive compensation applies, quote, to all educational programs that an institution offers, again, to the point that Aaron just made, and all contracts that an institution enters, and along with agreeing to amend its procedures for program reviews and changes. The third point is not part of the response letter. It was actually buried into one of the pages of the report, but we wanted to kind of pull it out because we thought it was pretty important too. Within the report, GAO said that it indicated that it's reviewing its guidance on the incentive comp ban and how it applies to OPM arrangements for possible revisions to address some of these issues. So don't really know what that means or what they're getting at here, but certainly could be broader than just the GAO kind of narrow report as well here too. And also in their response letter, they explained that while work of GAO was limited kind of to this narrow topic, the issue identified may have broader applicability to other parties to the OPM contracts as well. So by these two bullet points, they're kind of telegraphing potential other issues, if you will, or responses or actions. Last, I'll close with what to expect. So first, institutions can expect updates in the compliance supplement, the program review guide, the FSA handbook. That was pretty well telegraphed by Ed in their responses. I think Ed is probably in the process of drafting that, if not already. So certainly something to look out for. Number two, anticipate institutions will be required to provide copies of all OPM agreements and documentation evidencing how OPM recruiters are compensated. So to the extent that the institutions need to gather that might be helpful as well. Also worth mentioning, OPM, GAO defined an OPM very broadly here. In the report, they stated an OPM is a third party that works with a college to manage services necessary to develop and deliver an online program that includes at least 2 courses. So they specifically kind of exclude MOOCs and those single courses, but include short-term programs, micro-credentials, boot camps, right on the report as well that they include. Third, they state that schools might be required to fully disclose OPM arrangements to prospective and current students is one of the main disclosures institutions have to make. And last, not necessarily what to expect, but something to think about, institutions with OPM arrangements may wish to discuss or start thinking about or having internal discussions about what happens if law or guidance changes and what occurs to the extent Ed is asking for a lot more information about a particular program. And with that, I think, Aaron, I'll give it back to you.
Thank you, sir.
Nope, one more. Yeah, and last point, Ed is already, and this is a really important point, increasing enforcement. So according to their data, 16 completed compliance audits and 5 program reviews have, since 2012, none of those violations involved the college's relationship with an OPM, but as we're expanding the use of OPMs and as education has indicated, they're going to have more scrutiny here. Important to know that the agency is currently conducting 5 program reviews involving OPM relationships. So certainly to be expected to be increased going forward.
Yeah, and I think, I mean, those of you who have been, I'll comment here while you're looking at the next secret word. You know, I think those of you who recall sort of the step up in enforcement, for example, around Title IX, right, during the Obama administration, it is not inconceivable to me, given the extent to which this administration is interested in this topic, that as part of sort of the enforcement unit inside of the department and others' activities, that they will really attempt to step up the examination of these agreements. I think the primary limitation on that will just be their own internal resources. It is my impression the department is still struggling just to keep up with their current schedule, much less to take on additional responsibilities. So, you know, even if they want to expand those examinations in the context of program reviews, et cetera, I just don't know how much time they'll have to do that. But I think the interest is certainly there, as we see from their current efforts and just the change over the last year. So now, and I will say, we're going to give Chris Murray more than 2 minutes. Chris, we've got we've got 2 minutes for the CLE, but we've got the platform for another 15. We only have a handful of questions. So I would say take your time, because I certainly want you to have an opportunity, I know you've been thinking about this, to sound off. So I'm going to flip our slide onto our favorite slide here for our lobbying and policy friend, the crystal ball slide, and ask you, yeah, what do you think? What do you think from our fellow inside the Beltway?
To use a cultural reference for my time, whenever I see this slide, I feel like Johnny Carson. So thanks for this, Aaron and Scott. Really appreciate all the content here. 4 points just kind of overall on the political and policy environment around OPMs and institutions in this area. So the first is, as was mentioned earlier, there have been 2 letters from a group of Senate Democrats led by Senator Warren asking questions of the OPM providers about their operations, their contracts, and kind of how they operate. We have no idea what that is going to kind of amount to. Is that just information gathering? Is it going to lead to legislation? I don't think we're necessarily sure at this point. But I wouldn't be surprised since at least the second Warren letter did kind of expand the scope and ask additional companies questions. If at some point this group of senators started asking some large institutions that have a lot of these contracts, how it works on the institution's end, since the institution is actually the entity that's kind of most responsible for compliance, considering this is their Title IV. So I'm not predicting that, but it wouldn't surprise me if that was the next step in this endeavor of asking questions from the Hill. Which naturally leads into my second point. So, say after all this information collection, Senator Warren and others want to make some legislative changes to the overall OPM environment. So if they wanted to do this, how would they do it? And the only answer is the Higher Education Act. So, these are provisions that have been on the books for, about 30 years, as Aaron mentioned. The law can always be changed, but we're in a very weird holding pattern when it comes to the Higher Education Act historically. As many of you have probably heard me say before, because I mention this all the time, before 1998, Congress reauthorized the Higher Education Act every 5 years or less. Between 98 and 2008, we had a 10-year break. And then now we're on a 14-year break and counting, and it doesn't seem like there's any momentum around HEA reauthorization. So, if the legislators wanted to do something in this area, their best bet is HEA reauthorization. And despite the fact that there was a little bit of momentum around HEA, I would say a little bit, not a ton, in the 2015 to 2020 era, it really feels dead right now. And certainly if Republicans were to take control of Congress next year and say they wanted to do HEA, I certainly don't think this would be on the top of Dr. Fox's list, or potentially it could be Health Committee Chair Rand Paul in the Senate. So I just don't think this is going to be in their overall priorities. The other thing to mention there is there are other legislative vehicles that could kind of be used in this area, but they just seem very unlikely to me. The one that kind of sticks out the most is the appropriations process, but I would think there'd have to be a ton of momentum that's pretty bipartisan on Capitol Hill to kind of modify the overall legislative landscape of these relationships in order to get something like that to happen in the appropriations process, and I just don't think that's going to happen. So, I think the end of all of this in my mind is all roads really do lead back to the U.S. Department of Education, likely for the next several years in this area. And that gets to my third point. And I think this is a really important lesson that we learned from the Obama administration, and it seems like the Biden folks are taking very, very seriously. It's very, very easy to tear up guidance. That is how, for example, the Title IX rules were pushed out during the Obama administration. The Trump administration went through the very, very difficult and onerous task of rewriting the Title IX rules, and now the Biden folks are going to rewrite them again. Regulations are more durable than guidance. They take longer to stand up. They take longer to tear apart. So, I just think it's a very, very important point to note that if we're not getting legislation, regulation in this area is the thing that would kind of last at least for several years to come and would not be potentially torn up by a new administration in their first couple of months. And it does seem, at least from the outside, from what I'm seeing and what I'm hearing at this Department of Ed, I don't think panic is necessarily the right word, but there is a strong sense of urgency that 2024 is around the corner, and our friends over at the department seem to be trying to do as much as they possibly can, as quickly as they possibly can. So that's why what Aaron mentioned about, the institutional eligibility section and the forthcoming rules that we'll see this summer, it's going to be really, really interesting to see whether that provision that was floated in March makes it through to the draft rules that we'll see this summer. And then finally, just kind of overall optics and kind of lobbying efforts here in Washington. So higher ed is odd, as I've come to learn, because I started in higher ed, so it seemed totally normal to me. But as I've expanded into K-12 and early childhood education, there are very few industries that have as many trade associations as higher education. I mean, it's just amazing to me that, the Jesuit colleges and the business officers have their own trade associations. It's very, very granular in the higher ed world here, advocating for institutions and kind of subparts of institutions. There, as far as I know, is not an OPM trade association. There is not one group that is kind of lobbying for, particular OPM policy. So ultimately, a lot of this is driven by the institutions themselves. And having worked with institutions for many, many years on Capitol Hill and at the White House and, before the U.S. Department of Education, I will tell you, it can be very difficult for stakeholders inside institutions, as many of you who are listening right now know, to kind of get the attention of the president's office in a way that will, make that president decide that it's in her interest for her institution to engage their internal government relations function to push for or against a particular area. Institutions are very complicated, as you know. They've got lots of different permutations and lots of different care-abouts. So, in particular, it can be very, very difficult, even if there's a cherished vendor relationship with that institution, to get that institution's attention to actually then spend political capital with their delegation on the Hill or their relationships at the U.S. Department of Education and inside the administration to change a policy they might not like, because that institution might also have a pending program review with the U.S. Department of Ed. They might have earmark requests pending in Congress. They could be building a new Department of Energy facility. There are a lot of pulls on the government relations office at these institutions, and it can be really, really hard for something kind of this granular, this complex, and really based on the vendor relationship to be something to get the institutions to roll up their sleeves and lobby on. So, at the end of the day, the dynamics that I'm seeing is there's not one coordinated effort with the trade association by the vendors here. And on the other side, it's very difficult to get the institutions to actually care enough. And I don't mean that in any kind of disparaging way to the institutions. I actually mean that with a whole lot of dignity and respect to the institutions, because they have so much that they've got to cover every single day here in Washington. So it just can be very difficult to get the institutions to care enough to put it at the top of their list and start asking for favors, let alone having an overall strategy on this. So that's kind of where I see this all going for the time being. I think this is going to be Department of Ed focused. Finally, I guess I would also say that I don't think this is necessarily at the tippy top of this cohort at the U.S. Department of Ed's list. They've got a lot that they're trying to accomplish. I do think that they care about this. But if I had to kind of give you a list of their, top care abouts, I don't think I would put this kind of at or near the top of the list. So Aaron, that is my crystal ball. Back to you.
Thank you, sir. Really appreciate it, Chris, as always. I will just real quickly, I do want to do Q&A. Just going to want to point out to you guys, we got a couple of things back here at the back. I mentioned earlier we did a webinar last year where we did a very thorough discussion more generally of the incentive comp prohibition and its history and some of the other things that commonly come up under incentive comp questions. Delighted for you to take a look at that. I've also included, we have included an incentive comp rule timeline here at the back that includes links to most of the key federal registers and rules and the Higher Ed Act, et cetera, that have come along over time, including some key litigation. And then finally, look, we've got our blog. Would love for you to check that out. If you didn't see it, we actually did a blog post on this topic last week. We've got our webinars like this one that are all on demand. So they're always free, and we're happy for you to go back. If you thought this was useful information, by the way, I don't usually do this, but I'll put in a pitch here. There's a lot of really important stuff coming out of the department right now with these rulemakings that affects all of higher education in a pretty serious way. It's not sector specific. I fear sometimes that there is a view that most of what the department's doing right now is focused on proprietary institutions. With all respect, I think that is a misconception. I think there are many very important things that are being bandied about that would affect traditional higher education, just like this definition of nonprofit. If you're concerned about this or you think this is important, please feel free to pass the webinar on or highlight it for folks or just talk to them about it. You don't have to tell them you've heard about it, Thompson, Coburn. But it's really important that when these proposed rules come out, people comment. That's how the department hears about the concerns, among other ways. And I just want to make sure that the community is plugged in and is paying attention. We've got some training series that are out on YouTube and other places. Again, all free. We did one on Title IX a couple of years ago when the new rule came out. We will be doing one when our next iteration of the rule comes out. And then we often put out, again, free white papers on topics that are of concern to folks out in higher ed. One of them, which will be reconsidered by this department, is the financial responsibility reporting. So we have a guide on, what you're supposed to report to the department, certain financial events, and that is changing. That's one of the rules that, again, is under consideration. And then finally, our disclaimer, we're not your lawyers, unless we are your lawyers, in which case, give us a call if you have a question. We've got 5 minutes left. We've got 2 great questions. So the first is, it seemed to me that the GAO was drawing a distinction between individual one-off courses and programs with regard to the applicability of the incentive comp ban. Is this accurate? Now, there's a second half to this question, but Scott, my view is the GAO was asked to speak specifically to OPMs, and so they had to define what is an OPM. So I think for purposes of the GAO report, they excluded courses and programs. And you spoke to this a minute ago. Am I accurate in that?
Yep. Yeah, you sure are. And
okay.
It's footnote 16 in the report, and they actually just go out and say they base their definition off the one used by List Ed Tech and EduVentures Research, and they make clear that Department of Education does not define OPMs. Yeah, I'm sorry.
That's right. And so here's my answer to the question asker. Yes, the GAO put a box around the definition of OPMs, and they were directed to report on OPM relationships. But that does not mean that the incentive comp prohibition doesn't apply to non-OPM relationships, right? So you have bundled services providers, for example, that aren't OPMs or don't provide online platform management who are still subject to incentive comp. I think similarly, you could easily have a relationship with a bundled services provider or any service provider where they might just be assisting you with a single course. But if they're engaged in covered recruiting activity and your relationship with them involves a revenue share, I think you could still be covered by incentive comp. So it's a great question, and I thank you for asking it. And I want to just highlight for folks, it is my professional opinion that I would not conflate GAOs drawing a box around the definition of OPM with GAO drawing a box around the applicability of incentive comp. But it's a great question. The second part of the question is there any statutory regulatory basis for that assessment? So my point is no. I think the statute, if you go back and read that slide earlier here, doesn't draw any lines based around whether you're an OPM or not. And then it says if an institution has an OPM partnership over just individual non-credit MOOCs versus like a MOOC series, for example, does the incentive comp ban apply to one but not the other? Again, I think the key question is, if you have a contractual relationship where someone is recruiting on your behalf, this third party, whoever they may be, is recruiting into your program or your course or your whatever it might be, if they're engaged in cover and recruiting activity and you are paying them based on their success, a share of revenue generated from whatever it is the student is attending based on that third party success in recruiting, I think you've got to seriously consider the applicability of the incentive. I mean, if you were my client, I'd want to see the contract, but I would not exclude the possibility simply because it's a MOOC or it's a single course, et cetera, right? The last question that I have is, do these changes apply retroactively? Also, really a great question. institutions are entitled to rely on guidance. And there's a distinction under the APA between sort of formal rules that go through rulemaking and a different kind of what I'll call sort of an informal rule. But if it's a published interpretation of a rule, and I would say the 2011 guidance is clearly a published interpretation of the incentive comp rule, an agency can't just willy-nilly, arbitrarily change their view and then start penalizing institutions that may have entered into relationships or done something that was consistent with that prior interpretation. So let me take a step back and say they can do it, but they should not, and it would violate case law and the Administrative Procedures Act. Now, that might mean that an institution has to take them to task. In fact, I will say we've seen agencies try to do this, but it's not supposed to work that way. So there would be some defense on the part of institutions, and I think if the department were to come out with new guidance, the expectation would be there would be a transition period where institutions, if they have a relationship that's violating the new interpretation, would have some opportunity to transition. Otherwise, I think there would probably be lawsuits and big issues that the department could otherwise avoid. Last question. I know we're at 3:15. I apologize if we get kicked off the platform. Really quickly, can you differentiate between an OPM and a BSP? Yeah, so a bundled services provider, we did talk about this earlier, that's any third party that's providing you a group of services. And those services could be any type of services. OPMs are a subset. They're providing you a specific kind of service, online platform management. So OPMs are a type of bundled services provider, in theory, if they're providing you with a grouping of services and not just one. But there could, in theory, be bundled services providers that aren't OPMs, that are doing something else. And there are many out there. One is OPMs are sort of a subset of BSPs, a huge subset, but a subset, categorically speaking, nonetheless. Thanks to everybody for tuning in. Don't forget the surveys. We always appreciate your support and hope that this has been helpful. And again, if you're concerned about this stuff, we also encourage you over this season of heightened rulemaking to watch for proposed rules, pay attention, and issue comments if you think it's appropriate to do so. Thanks, everybody. Thanks, Scott. Thanks, Chris. Really appreciate your time. And Stephanie Richter, our producer. Appreciate you as well. Have a great afternoon, everyone.